So, hi there. My name's Rena Sond, and after 22 years as a commercial and IP lawyer, I left the corporate world to set up my own IP consultancy in Tangent. And today I'm going to be talking to you about the intellectual property basics and fundamentals, as well as the mistakes to avoid. Um, I will be looking to tailor some of this content and gear it towards yourselves as retailers. And if there's any queries, then you can contact me and details will be shared at the end. So turning to IP, we will cover, let's start the fundamentals. I like to think of IP as being like hidden treasure in your business. And that's because a lot of the time, IP assets are sitting there in plain sight, but not always very visible. And that's intellectual property for you. It's another word for it is intangible assets. And figures show that on average, IP forms up to 95% of a typical business's assets in this day and age. And that applies just as much to independent boutiques, high street cafes, or small retailers, as much as it does to a tech company or a product manufacturer, say. So IP is a valuable asset for many companies and is important to the success of a business. It essentially exists to help protect your ideas and to help innovation and growth. These are the main forms of IP. Essentially, you need to try and protect these rights in the same way as you would protect any assets. And these can give you very many benefits, a whole range of benefits, which were set out on this slide. Many businesses don't actually realize true value of their IP and what it could be worth when it's used strategically. So it's important to secure your rights, because if you don't protect those rights, then essentially you'll be losing out on control, on the legal rights to sue others if they breach those rights. You can potentially lose out on revenue, importantly. You can also end up losing out on value if you're looking to sell your business, and competitive advantage as well. So these are really important. These are the main types of IP on this slide, and we'll go through each of them in turn. But the ones on the left-hand side are the main IP rights that I'll be focusing on today. Before diving into that, I mentioned about IP assets or intangible assets often being hidden in your business. This is quite a useful slide that I thought I would include, because this gives you an example of the different types of assets that you may already be dealing with in your business. And so if you can spot certain keywords on here that are relevant to you, such as your customer relationships, training materials perhaps you have in your business, or a website, then it's very, very possible that you have some form of IP protection and IP rights that are worth protecting. So let's dive in. First, onto trademarks. Trademarks are used for brand identity and distinguish your goods and services from others and make you stand out from your competition. They can help to create trust and loyalty and allow you to command premium prices. Just think of the big brands out there like Coca-Cola, clothing brands like Boden, banking systems even like Monzo. These brands all have created relevant positioning and branding for themselves and been able to charge premiums for what they're selling. But you can also think about your own business name. It could be a boutique, it could be a business brand, and so on. And so trademarks protect these brands by registration and can last for 10 years when you register them at the UK IP office. These rights can be renewed, so actually your trademark protection can last forever. And essentially registering your brand, that could be your business name or logo, it could even be jingles or strap lines. These can all help to protect the reputation of your brand and to stop others, importantly, from setting up any similar named or identical named business. And to be registered, the brand has to be distinctive and not descriptive. This is really important. When you register your brand as a trademark, you also have to select various goods and services that you use the brand under and protect in those particular classes or categories of goods and services. What you need to be careful of when you're registering a brand is that it must be distinctive. So, to give you an example of that, if you were a small coffee shop and you decided to call yourself and brand yourself as the coffee shop, or if you were a florist and called yourself Fresh Flowers, those won't be accepted for registration because they're too descriptive and generic. They're not distinctive enough as names to be protected as a registered trademark. So do choose your name carefully. These are examples of some of the names and logos that can be registered as trademarks. As you saw on the previous slide, you can also actually register corporate colours as well. You get Cadbury's purple, which everyone will usually remember. And so certain colours can also become synonymous with your business or brand as well, just by way of a further example. So then turning to patents, they're not hugely relevant to retailers, but they're worth covering so that you're aware of what these cover. They are essentially granted to owners of new or enhanced inventions. That can be a product or a process and can last up to 20 years. So a patent usually grants the inventor the right to stop others from making, using, or selling their invention without their permission. And really famous examples of patents will be Dyson patents over the Dyson products out there, including the vacuum cleaners and including things like hair straighteners and things like that. They're less common, as I say, in retail, but they can apply to a genuinely novel product or process. So, for example, that could involve an innovative food production method, or maybe even some unique packaging mechanism that you've used in your gifting service, for example. As I say, it's worth being aware of, but for most retailers, I'd say that trademarks, copyright, and design rights will be your primary tools. And speaking of which, let's move on to design rights. So design rights can be registered or unregistered, but essentially these protect a product's visual appearance. That can be for the whole or part of a product and can cover things like your colours, the shapes, or the texture of your products. And registered designs can last up to 25 years and they're renewable every 5 years. If you are not registering the designs, as I say, you can have them unregistered. They only last up to around 15 years. So you do get extended protection if you register your design as well. So that's something to bear in mind. And by way of examples, that could apply to your product packaging. It could apply to the shape of your bottles or containers for new products that you've developed. It could be fabrics or surface patterns on clothing or, say, homeware goods. It could even be the distinctive look of your shop front or brand signage, or where you provide bespoke stationery or gift wrap designs, for example. So design rights can be really useful and they're fairly inexpensive compared to other types of IP protection. So they're worth considering. They're often overlooked not just by small retailers, but by businesses generally. So they're not quite as popular or as well known as patents and trademarks, but they are still very useful, especially if you have invested in a distinctive look of any particular products, then these rights can really be quite handy for you. So next, turning to copyright. So most people have heard of copyright, but essentially it says what it does on the tin. It is the right for your own original work to not be copied by others. Now, with copyright, there isn't a registration system in the UK. Instead, the copyright arises automatically when you produce some original work where you have expended time and effort putting that item or thing together. Often that can be literary, it can be dramatic, it can be musical or artistic work. So it can include the elements on this slide, and in particular for businesses, it will be relevant to any documents that you create. That could be things like instruction or training manuals. It can also apply to the content of your marketing materials. That can include your website and brochures and flyers and so on. It can include sound recordings, as I say, and also books is obviously a very common one. And in most cases, you'll recognise the copyright symbol, which is the C in the circle that you can see here. And that will be used or placed usually within the inside covers of the books or at the beginning of any film or broadcast. Copyright rights, as I say, arise automatically, and they last for usually around 70 years after the death of the author or the creator. And the party that owns the copyright will normally be, by default, the person that created or that was the author of that particular work. An important point for retailers is that, as I say, copyright belongs to the creator. So it doesn't belong to the person who commissioned or paid for it unless there's a written agreement transferring the copyright ownership to you. So this is something I'll come on to a bit more later, but it's important just to note that it is the owner's property when it's first created, the person that's created it, that is. Now, you also have database rights, which are similar to copyright and arise automatically, but they cover databases or compilations of information that are pulled together systematically in a database. That could include things like your customer mailing lists, it could be loyalty card records or lists of your suppliers, for example. And all of these do actually have commercial value and deserve to be protected. So where copyright arises automatically and you can't register it, how do you protect that? That's a really good question that's often asked. And there's lots of practical ways that you can stop others from copying your work. Often that will involve documenting different elements of what you're creating. So that can be things like, as I say, training manuals or policies, things like records of products that have been created by your staff or your suppliers. And it's important, if you have those sorts of documents, to use copyright notices that are used on this slide as an example. And that just essentially shows people that the work that you have created is protected by your copyright. And you would normally put the name of your business next to the copyright symbol together with the date of creation. That's a really useful little way of showing and stopping others from copying your work. You can also use other practical methods like using watermarks on photos, for example, in photography businesses, or making sure things like technical tools are used to stop people from lifting and literally copying and pasting your website copy, for example. So useful tips there for you. And then in particular for retailers, I've just included a slide here which shows you the sorts of things that can be protected by copyright and other IP rights here versus what isn't normally protected. To give you a couple of examples, a recipe, a blend behind a signature dish or product, for example, can be protected as a trade secret. That's the next thing we'll come on to. Sorry, I'll move on to this slide. So inevitably, there'll be some sensitive commercial information in your business that you wouldn't want your competitors getting their hands on. And that's also known as trade secrets, especially where they're valuable. And as I say, an example of a trade secret would be things like a recipe for a signature dish that you might be selling in a cafe environment. It could be a formulation for a skincare product that you might have developed. Um, Essentially, if a competitor could replicate that product and copy it, then it's definitely got value that's worth protecting. Trade secrets are also often used in the food and beverage industry. So, for the likes of the Coca-Cola recipe, that's one of the most famous trade secrets out there. But also for things like KFC, the Seven Spices recipe, and also on your bottle of Pimm's, that's also a trade secret, the recipe of that. Trade secrets will only be valuable, again, they're not registered anywhere. They'll only be valuable where reasonable steps have been taken to keep that information secret. So it's really important to put measures into place to avoid that confidential or sensitive information from being leaked. And again, I've included some tips here for what you can do to stop others from copying your trade secrets. Essentially, you want to make sure you're keeping dated records of those items and ensure that you keep even early drafts as well, because if anyone ever accuses you of copying their recipe, if you pull out a dated record or draft recipe that you may have scribbled down, which predates theirs, then that's pretty good evidence that you came up with that recipe yourself and that you didn't copy somebody else. So it's a really handy way of just protecting yourself by keeping these sorts of records and draft documents. Even samples of products that you may have created, keep hold of those early samples because they can also be useful for you to protect yourself if you're ever challenged. Obviously, with trade secrets, you want to try and limit the amount of people that actually know it. I believe the Coca-Cola recipe only is known to 2 living individuals, for example, and the rest of the recipe is kept in a vault, I read recently. So that shows you how valuable protection and how important protection can be for keeping those trade secrets completely secret and confidential. It can be useful just to be really organised in the way that you're managing and keeping any documents so that they are kept and marked as confidential where they actually are. And again, in terms of anything that's kept on computers or electronic gadgets, then you want to make sure you've got really secure IT systems in place. And particularly with the amount of cybersecurity attacks that are happening in this day and age, it's important to make sure that anything that you have that is confidential stays that way through putting tools into place, using password protections and things like that. It can be helpful to obviously train your staff as well. That's really essential to help your employees realise the importance of keeping trade secrets confidential. As part of that, you will obviously want to explain the dangers of disclosing the information, and you possibly also want to set up a reporting process as well if there are any breaches or issues that arise. I think for smaller businesses, just having a short conversation initially on a staff induction when somebody joins is usually enough where you're just explaining about certain things being kept confidential. So it doesn't need to be anything overly formalized necessarily, depending on the type of business you are. And then lastly, use contracts. Contracts are essential for protecting your business relationships and your confidential information. For example, if you have new suppliers starting with you that have worked with your competitors, you probably want to get them to sign a contract which asks them and actually obliges them to keep your information confidential and not to disclose it to anyone else and none of their other customers. You can also use NDAs or non-disclosure agreements or confidentiality agreements, as they're often known, before sharing the details of, say, a new product or recipe or concept. And that can be used as a document when you're sharing that information with potential stockists or people that you might be looking to collaborate with, for example. So those are the different types of IP, and I've included this slide of the different IP rights summarised, just so you can see at a glance exactly what different types of IP exist, what they each protect, and how long they last as well. So, moving on to the common mistakes. One of the biggest things that I see is where businesses haven't really carefully chosen their business name when they set up. And they've not realized at the time that there is another business with the same name out there already. So it's really vital to do your research and carry out these 5 essential searches I've got on this slide to make sure that you're not going to be copying or infringing on someone else's business name. And that will avoid a whole load of headaches later on. And the timing of that registration, if you're registering your brand name as a trademark, can be really crucial because often the timing and the trademark system works as a way of it being a first come, first basis. So the earlier you can get your trademark registered before somebody else tries to, the better protected you are. And you can stop somebody else from registering the trademark or the same name if you already have a registration. So that registration really does give you strong protective rights. And that sort of scenario I see far too often with small retail and product businesses. For example, I had an old client who overlooked doing these searches when he first set up his eco-friendly product brand name. And he thought it was fine to use, but after being established for a few years, he was hit with a trademark infringement claim by a large international brand who then shared, who was basically sharing part of his name. So it was part of the name was their name. And they had several trademarks registered. So unfortunately, it meant that he ended up having to rebrand his entire business as there wasn't any real defense. And it meant wasting tens of thousands of pounds in wasted products which were in the old brand name and packaging, and having to spend more money on new products coming up with a new brand name and packaging. And that also included having to spend on a new website, changing all of his social media handles, and other marketing as well. And these simple searches at the outset could have saved him a lot of cost and headache. And it ended up being a really hard lesson learned for him. But as I say, one that I see quite often, unfortunately. So for a retailer, a rebrand will also mean things like reprinting labels, tags, packaging, signage. It could mean uniforms, menus, websites, anything that has your brand name displayed on it. If you find someone else has already beat you to it and got a trademark registered with that name, then that rebrand can become more and more expensive and perhaps the only alternative option for you. So it's so important to do your searches first. So the next issue that I see quite often, especially online, is where people use the wrong symbols when it comes to their IP. They mix up the different types of IP very often, and they talk about things like copyrighting a trademark, which isn't technically right, but they use the wrong symbols as well. So it's important to register your trademark to get the strongest protection, as we've talked about. And if you do that, you have the right to use the R symbol in a circle shown in the second point of this slide here. You can only use that R symbol where you actually have a registered trademark that's been granted. If you use that on a trademark that hasn't been registered anywhere in the world, then you will be doing so unlawfully. So it's really important to make sure you use the right symbols. If you don't have a trademark registered, then the TM letters you can use next to your mark. And that just shows others that you're using it as a trademark, but it's not actually registered. And then copyright we already touched on, and that means simply using the copyright, playing that to show others that the work that you've created belongs to you. Next is the mistake of assuming that you own your IP. Now, 75 of businesses don't actually know who owns the copyright, for example, when they use a subcontractor or a freelancer. And this can be the biggest and costliest mistake that businesses can make if they don't have clear ownership of those IP rights. That can be your trademark, it can be your patent, it could be the copyright, it could be your design right. And the issues that that can cause mean that it can stop the sale of the business, or it can affect the value of that business if you're looking to sell. It can hinder your ability to raise any funding or investment. And it can mean it's difficult to seek any kind of remedies from the court if your IP is infringed as well. And this type of ownership point catches out retailers constantly. And a common scenario that I see is where you might commission a graphic designer or a branding agency to create a logo. And so that's essentially their copyright because they created it. So it's important to have a written assignment of copyright, a written transfer of copyright, which shows that they are transferring the ownership of that logo or design to you. The same thing applies to a photographer to shoot your products. You have the same issue. As the photographer, they actually own the copyright in the images that they're taking. Even if you've commissioned and paid them for those photos, they still own it by law. So you've got to get an agreement in writing transferring the copyright ownership to you. It's only then that you can claim that you own the copyright and the IP in the work that you're getting commissioned. And to give you an example, Innocent Smoothies had this very issue when they first set up. They actually commissioned their little smiley face logo and got a creative agency to help design it. And they had a slightly different scenario in terms of payment for it, but essentially, because they hadn't been paid, their terms had said that the logo still belonged to them, and so it hadn't been transferred. And so when Innocent came to check what they owned because they were looking to sell, they realised that they didn't actually own the logo, and they had to spend time and money getting it transferred to them. And they did end up in court as a result of it, and ended up being taken to court and settling as a result of that. So again, ownership can be really important. You might not think it at the time, but further on, especially if you're looking to sell or do things with your IP, then it becomes more and more important and relevant. So it's good to get it right from the start. The same thing applies to employees as well. So when you get employees who are creating things for you in your business, make sure that the IP that they're creating belongs to you as the company. And that will often be through employment contracts. Now, by law, if you've got employees, what they're creating belongs to you as the owner, as the business employing them. But it's still good practice to put it into an employment contract so that employees understand that it is yours as a business owner and not theirs. So the next issue and mistake that I see businesses is that they go to the efforts of protecting their trademark and then do nothing else with it. And it's for this reason that I've developed a strategy to really help you understand what you should be doing when it comes to any IP that you have in your business. First of all, it's obviously understanding what IP you actually have, which we've already run through. And it's worth taking some time just to sit and think which of those IP rights belongs to your business. Then it's a case of assessing what you've got and looking at whether it's worth protecting any of those rights through registering them where they are worth protecting. And then once you've protected your IP, the important thing is actually what happens next. The protection of your IP is just the first step. And I always say this to my clients, that's fine and well to get it protected, but actually the more important bit and where you can create value and income for your business very much depends on what you do next. So that is where you then look to actually proactively exploit or monetize or commercialize your IP. That's essentially where you're actively using it to help you make money in your business. And that can be through lots of different methods, which I'll come on to briefly. And then finally, if you've gone to the effort of registering and getting IP protections and rights put into place, you want to be making sure you're monitoring the competition, monitoring the market, looking out for what's coming up so that you can enforce your IP rights if you find that somebody is infringing or copying your business name or your products and so on. If you've got these rights protected, then you can use them to enforce those against other copycats. So I talked about making money with your IP in different ways, and there are all sorts of different ways you can do that. One of the most common ways to do that is through licensing. Now, licensing is essentially giving somebody permission to use your IP. That can be your brand, it can be your logo, it could be your designs of your products, for example. And this can be really helpful because it can give you lots of different revenue streams potentially where you're giving somebody else permission to use your designs. I'll give you an example. I acted for a client a number of years ago who had designed and developed some eco-friendly baby products. That included things like baby carriers and harnesses and so on. And they had registered their product designs because they were quite unique designs. And they had called the different product lines different brand names, and they had registered those brand names as trademarks. So they'd taken all the right steps, and then they were approached by a large baby products manufacturer in the industry. They were already selling these products quite successfully into major retail chains across the UK. And the large manufacturer approached them and basically loved their designs and products and what they were doing and wanted to work with my client. So we negotiated the terms of a license arrangement where we gave them permission to use the brands and products and to manufacture them and then to sell those products into the US and China. And that then meant that in return for them getting that permission and that license, they were having to pay royalty streams to my client in return for that. So they basically used my client's IP, sold the products using that IP into bigger markets internationally. So my client's brands got further brand reach and grew in brand equity. And she was able to get them to do the hard work of establishing those relationships with retailers in those countries and having all of the logistics and dealing with all of the sales of those products and distribution of those products into those retail stores without working hard, just simply by licensing her IP, which she'd already spent time and effort in having done all of the hard work early on. And she was able to sit and basically collect royalties, which was a small percentage of every sale of those products that was made in return for the IP that she created at the outset. And that's a brilliant example of how you can really make money and create revenue streams by using your IP to its full advantage. Quite often with retail businesses, you will see that often play out in the form of a franchise. And so franchises are great ideas for essentially licensing your brand and logos to others who then sell your product lines, or different product lines even, including things like tea towels, food products. Starbucks, for example, have their brand and logos that they license to licensing agents and partners, and those partners then sell the sell the Starbucks logos on different types of food products, cups, coasters, homeware, tea towels, you name it. It's pretty much everywhere. And lots of restaurants and cafe chains have actually done that to then merchandise a lot of their branding onto different products. With franchising, sorry, coming back to that, is if you've got a successful business format, that could be cafe or a retail format, a franchise allows others to replicate the business under your brand. So again, you're in a prime position to get a license, grant a license and get royalties in return for somebody else using your brand. Again, early on, you would have created a big system and uniforms and signage and so on, and built up that goodwill and that brand recognition. And so franchising a cafe, for example, to another business owner that wants to leverage that means that that cafe chain then becomes more recognized, and it can then spread and be franchised even further and further, and you as the main owner of that brand will be able to collect revenue streams from each of those individual cafe businesses. So again, that can be a really useful way. There's other ways as well. It could be that you have a load of IP that you're no longer using, where you might have changed business direction, so you could potentially sell that to somebody else that might be wanting it. It could be just where you're creating and selling new products yourself as well. So there's a whole range. I'm not going to go through all of these, but they're just useful to know. And if you ever need help with any of these ideas or contracts to protect you when it comes to monetizing or commercializing your IP, then that's the sort of work I do with my business. So, a quick question for you. What do brands have in common? They all started off doing something completely different to what they're known for today. And that really sharply conveys the message that your brand and IP can evolve and it can grow in ways that you don't always anticipate at the outset. And that's exactly why protecting it early on matters. Giving you an example, Tetley's actually started in salt, selling salt in Yorkshire, and then they pivoted to tea. And Lego started off not making those plastic bricks, but actually wooden toys back in 1932. And that's become one of the world's most valuable brands through consistent product design and trademark protection. But these are all examples which I think are great. And so for aspiring retailers, I would say don't be locked to your current products or formats. Instead, it's important to be committed to solving problems for your customers, and your brand, as long as you've protected it, can build and grow in value and travel with you through your business journey, whichever direction you go. So, just to end, as we've seen, there's a lot to learn about IP, and it can be a bit of a minefield because there's lots of pitfalls that we've covered that can happen along the way. So it's always best to take advice if you're not sure about what to do with your IP. What I would also say is that I'm conscious we've covered quite a lot in today's session, and so I would break it down to three key takeaways to remember. And that is to just know and understand what IP you have in your business. That's your brand, your products, your content, your customer data. They're all assets. So don't overlook them. Next, have some sort of a plan or strategy in place. So do think about maybe checking what IP you have, registering what you think might be worth registering and protecting that, and then monitoring the market. And then importantly, as I say, commercializing, using and leveraging that IP in your brand to help you to create business for yourselves. And then the final point, as I say, use that IP to your advantage to add value. And as your business grows, you'll find that your IP can open doors to licensing, franchising, wholesale partnerships, and ultimately a better sale or exit if that's what you're looking to achieve longer term. So I hope you've enjoyed today's session. And if you're not sure of your IP or would like any advice on any of what I've covered today, then do feel free to speak to the Growth Hub, to Herts University's Law Clinic, or to myself at Intangen. And finally, do feel free to connect with me on LinkedIn, where I post regularly about various IP topics. Thank you so much for listening.